Okay, everyone, good afternoon. I just wanted to, if you're joining right now, I just wanted to give it a couple additional minutes for any last minute attendees to join, but we're at 1:02, so we're going to kind of just jump right into things. Today, we will be discussing the challenges associated with sourcing quality candidates in today's market. And my name is Sarah Baldeo. As I said at the beginning of the broadcast, I am the Division Director for Screening at ISB Canada. I'll be starting things off and just reviewing the corporate side of background screening, key hot topics in the market, and also different ways we can measure quality. Shana Wolch, much celebrated employment lawyer, will then be taking over, and Shana is going to be reviewing legal implications, concerns when it comes to background screening, and Shana and I are more than happy to answer any questions at the end of the presentation. So in thinking about the topic of this presentation, it really pushes us to evaluate how we measure quality. And it's not only a fiscal representation of quality, meaning when we're thinking about what is the return on investment of a particular employee. When we think about the topic or the term human capital management, what are some of the things that we think about? So I used to be in HR and recruitment myself, so we're thinking about how can an employee bring strategic value, in what ways can they assist with process improvement, how much time can they save an organization. But it's also, I think, very valuable to note that demographically, we perceive our value very differently just based on some general racial nuances. Now, if you look at this infographic entitled The Generations in the Workplace, we're looking at baby boomers. What are their key strengths? So they have a great executive presence, but when it comes to things like technology, maybe they're not so strong in those elements. When it comes to generating revenue and things like relationship building, Gen X shows that they have some great pros, so managerial skills, revenue generation, problem solving. And millennials, the last group, some pros of millennials, enthusiastic, they're tech savvy, entrepreneurial, but cons, at least as measured by this infographic, millennials at least can be perceived to be unproductive or maybe very selfish. So it's certainly important when we're thinking about quality to think about these demographic specific skills. Now, moving on to tenure, when we think about quality, and the title of this webinar is Identifying Quality Employees in a Competitive Market. Tenure is one of the most widely recognized indicators of quality. However, in recruitment, it's very apparent that today, tenure is not what it was 20 years ago. Now, this infographic shows us the difference in tenure in the 90s versus what it is today. Today, 51% of employees have been in a job for less than 2 years. So is this really still a predictor of quality? And I think it's also very worth speaking about the proverbial elephant in the room when it comes to HR and recruitment, being millennials. As I think any HR professional can attest, millennials have a propensity to stay in a role for a far shorter span of time than maybe their counterparts in other generations. But since millennials are, really the future of the workforce, perhaps it's worth reevaluating what we look for in references when it comes to tenure. So I think one of the greatest challenges of recruitment and identifying those quality employees is the supply versus demand equation. Today, there are more applicants than ever, and as much as we all believe in equal opportunity, there certainly has to be variables we use to measure skill and to sort through that huge amount of resumes that you have to get through, whether it may be education, previous salary, or income trajectory. Even these variables are not always set in stone. Now, looking at this infographic, wage growth by province, we can clearly see that wage growth is down in both Ontario and Alberta. And what does that mean? That means that individuals in these markets, when you're looking at their resume or you're having those phone interviews and you're asking them, what was your previous salary, their income trajectories may not necessarily be indicative of their skill. Now, in the previous slide, I touched a little bit on that supply versus demand equation in the recruitment industry. And here, I want to delve into the topic of not only what do employers want, but what do employees want? Now, currently, when we're looking at what people want most in a role, career progression and salary are ranked as the two most important aspects of a role. And for employers to remain competitive in that competitive workforce that we're talking about, they need to be cognizant of what the best people are looking for. As we can see, a good job title is only ranked as 8% in being it's not as important as it once was. Now, most employees think that employers are, somewhat unfair in what they're asking of employees, and here we can see the well-loved Dilbert comment being told exactly what is wanted from the employer. And as we can observe, it seems like from this perspective, from the employee's perspective, that employers want everything. But to be fair, I think employers simply want to build the best organizations. And our job in the screening industry is really to help employers do that. Now let's get into the details of screening now. Now, when we think about methods of identifying quality, it's really broken down into two camps. There is objective and subjective measures. Criminal checks, psychometrics, cognitive personality assessments, job culture fit. These are considered to be objective measures of quality. When we're looking at things like interviews and references, those are based on opinion, personal opinion. So those are more subjective measures. Now, getting into criminal checks, one of the things that I notice most when I talk to clients, and I was recently at a screening conference, is that a lot of employers, they'll request a criminal check, but they don't necessarily know what are they getting. So if they get a clear result on a criminal check, the question I always ask them is, well, do you know what databases were checked? Do you know where the information came from? Did you get it from the candidate? Did you get it direct from the source? And they don't always have the answers to this question. Now, when we look at the CPIC database, this is kind of what most people think of when you're talking about a criminal check. And this is conducted through a search of the Canadian Police Information Center. Now, one of the very important pieces of information I like to share with prospects and clients is the lag in the CPIC database. Now, just due to limitations in our judicial process or the way it functions today, if someone goes out tomorrow and they commit an offense, obviously they're not convicted right away. And even when someone is convicted, it doesn't necessarily hit the national database or the CPIC database right away. So there's some challenges with the information that is being obtained by conducting a search only from the CPIC database. Things like checks on minors, running checks on minors. We can't, as a vendor, no one can run a check on a minor. When we're looking at things like a VSS or a vulnerable sector search, a lot of the times clients in certain industries will come to me and say, hey, we want to run a check, a vulnerable sector search. Can you do that? No one, not a vendor, there is no person other than the applicant themselves that can obtain the vulnerable sector search. And the vulnerable sector search, really, the main difference is that this checks the sexual offender database, where there is no background screening company that has access to that database. And if they tell you they do, they're not really giving you accurate information. Now, when I talk about the CPIC lag, one of the ways that we try to get around that or to account for that in our screening criminal searches is by conducting a search of local police databases, which means that if you're conducting a search of the CPIC database and the local police database, you really are getting the most up-to-date information. I think it's worthwhile to mention here that when we're talking about criminal checks, another question that I frequently get is, okay, so you're running a criminal check and I'm going to know exactly what the person's offenses were. Now, due to the Police Reform Act that was passed a few years ago, we actually, as a vendor, cannot disclose to our clients the details of those offenses. We can say that the person has a criminal record. We can say that they don't have a criminal record. We do give the option. So you are mandated to give your applicants the option to self-disclose information. So they self-disclose the information, they declare their criminal record. When we conduct the search can say, yes, we've confirmed that based on their self-declaration, that is indeed what they are guilty of. But if they do not self-declare, and then the search comes back and says either A, they didn't declare or disclose all the right information, or there's some discrepancy, we can't then go into the details of exactly what is on their criminal record. One of the ways that we are able to disclose that information is by running provincial checks. Provincial checks do not actually require consent. They are, however, more costly, and they do take quite a bit of time because that requires a researcher to physically go to the courthouses required and obtain the information. One of the issues I will touch on is discrimination. There's a lot of clients, particularly in certain provinces in Canada, where employers will say, you know, I don't want to know too much information because I don't want to have the applicant accuse me of discrimination. The Privacy Commissioner of Canada, and even in the Canadian Human Rights Code, and Shana will delve deeper into this later on in the presentation, you are allowed to search or run a criminal check for the purposes of employment. When it comes to domestic violence charges, the reason I have that up there is it is important to note when you run a criminal check, if someone is mentioned in a police interaction, because of the Police Reform Act, sometimes you'll see a victim's name is mentioned, but due to the Reform Act, we can't tell you what that says. So it's also, I think, important as it is to run criminal checks, it's also important to be cognizant of where the information comes from, what we're searching, and how you can leverage that in your hiring decisions. Now, moving on to psychometrics. When we talk about psychometrics, I am a huge believer in psychometrics. And when we're talking about psychometrics, we're thinking about things like assessing cognitive ability, personality, job culture fit. It's really important to validate results. And what does that mean? That means that when you're asking an applicant to go through a psychometric assessment, it's important that you're aware of who designed this assessment when they validated it, meaning when they were designing the assessment, were they measuring this against what's called a representative sample set? And in plain English, what that means is if they took a group of people, was that group of people only from a specific demographic, or was it representative of the general population? One of the biggest questions, I think, with psychometrics is when should you deploy a psychometric? And I think that question really can be best answered. It depends on the type of the role. Now moving into more of the subjective measures. In no way as a screening vendor do we believe that our involvement makes interviews superfluous. But interviews take very valuable time. And the purpose of adequate screening is to ensure that when you do interview people, you're interviewing the right people. Some of the limitations of interviews, I mean, obviously, what if the person is remote? How many interviews can you conduct? You don't want to be interviewing every person that applies for the job. There is an element of risk if you're relying solely on interviews. There's an element, of course, of social bias. But it does give you an opportunity to measure the person's face-to-face interaction style. I know when I was in HR and recruitment, I've seen wonderful resumes, and then the person walks in and it's a horrendous interview. And I've, of course, seen the converse of that happen as well, where it's not the greatest resume and then they come in and they blow you out of the water. So certainly interviews are important, but it's also important not to rely solely on them. When it comes to references, there's a few different types of references. And just to clarify, a reference is very different from a letter of experience. A letter of experience, which is what a lot of employers are moving into today just to save time when they're providing information to a new potential employer for a former employee. A letter of experience just confirms employment. If you're lucky, there might be some detailed notes. Whereas a reference, generally speaking, provides far more detailed information. It's important to note that employers are not legally permitted to provide negative references. And also, as I said, references alone are not necessarily enough to make hiring decisions upon, since they're certainly somewhat subjective and it's third-party information. So there's definitely issues with legitimacy there. Now, when I mentioned psychometrics previously, I did touch on validity, and I went a little bit into what that means. Now, when an industrial organizational psychologist designs an assessment, they validate it against a representative sample set. And when we're thinking about assessments, I always say to clients, it's very important to find out who created the assessment, against what sample sets they validated the information, and to also be very careful in terms of the usage in hiring decisions. And the reason for that is most of the time, when an applicant is taking an assessment, there's an element of what is known in the psychometric and neuroscience industry as self-report bias. And that basically means, in plain English, we all have a tendency to think the best of ourselves. As I can admit very freely, I'm guilty of that, and certainly applicants are as well. So there is an element of self-report bias when it comes to assessments. Even though there's controls that are built into assessments to account for that, it's very important to just be cautious in the use of assessments. I'm going to touch very briefly on the consent argument. The RCMP very recently issued a new memorandum of understanding stating that they're only going to be accepting their consent forms as of November 1st of this year. Previously, vendors and employers could use their own consent forms. Consent is imperative, definitely when it comes to running searches on potential employees. And more importantly, informed consent, which means that the applicant knows exactly what type of search you're conducting and that you're conducting it for the purposes of employment. The importance of this is really due to privacy and compliance. The results of the searches also need to meet criteria of security in terms of where they're being stored, as well as any potential sharing of results internally. And really that means making sure that the audience that you're sharing the applicant's result with actually needs to know. One of the things I talk about very frequently with clients is make sure that you are only asking for information that you need to know, because too much information can certainly be a hindrance to you and in some cases can open you up to issues of liability. One of the final things I want to touch on is the duty of care argument. Really what this means, and I'll read it directly, is if someone does not act in a way or provide an appropriate standard of care to someone that they have a duty of care towards, then they have breached their duty of care. What does that mean in an employment context? You have a duty to provide a safe workplace environment, and in addition to that, safe coworkers kind of falls into that realm. How is this applicable to screening? There's been some talk in terms of the Canadian Human Rights Code and privacy that criminal checks and other types of checks will become mandatory in employment. And I'll give an example. If you hire someone and you do not conduct a criminal check, and then they come into your organization and they assault or commit some act of violence towards another employee, your employee is not going to sue the other person. They are going to sue the employer if they find out that you didn't conduct a criminal check, especially if it comes out that that individual had a criminal record. So the duty of care argument is certainly something that's coming up a lot in the human resources and recruitment industry when it comes to screening. A couple of key takeaways are just be cognizant of your applicant demographics, millennials, other generational nuances. try to make decisions based on both subjective and objective data. Effectively screen your vendors. So you have screening vendors, but screen those vendors. Make sure you know where they're obtaining information from. Are they asking you for consent from the applicant? If they're not, then that probably means that they're illegally conducting searches. Be very mindful of applicant fraud. That's why it's so important to ask for identification and ensure identity verification. And lastly, on that topic of duty of care, just be cognizant of what your legal obligations are. We will take questions at the end, but now I am going to just transfer things over to Shana.
Good morning and good afternoon. I'm just teeing things up on my end, so just give me 1 second here to make sure that I'm on the right slides. Okay, I'm going to speak to you now about the legal considerations that can impact employers' choices to do background checks. Can everyone see me changing the slide? Sarah, can you see that?
Yeah, I can see it, definitely. You're on the first screen?
Okay.
Yeah.
Yeah, okay. I've moved to why would an employer want to do background checks? Is that the screen you have?
Yeah, perfect.
Okay, perfect. All right, we're good to go. Thank you. Okay, so why would employers want to do background checks? And obviously, Sarah has covered this, and I'm going to come in with some of the other legal considerations. So, for example, why employers want to do background checks is pretty basic, and Sarah's touched on the fact that there could be legal implications already, but I want to highlight from even just being an employment lawyer and what I see with all of our human resources professionals on a daily basis is, you know, unqualified candidates and hiring, recruitment costs, continual exposures to risks of fraud and theft. There could be legal requirements, so Sarah touched on that too, but for example, you know, there's industries such as teachers or educators where you have to do background checks. But what becomes really important from a legal standpoint is the choice of background checks, how far you go, what is reasonable and what is too far. So why would an employer be cautious about performing background checks? Background checks have the potential to reveal personal information, and personal information can have the potential to ground a claim in either discrimination in human rights or breaches of privacy. There are also other potential legal claims, including up to defamation. Background checks can also be slow. They can take a long time. So there's an administrative burden that can be associated with background checks that can even just inhibit the start of work dates. All of these constraints on employers, and so it's important for us to go through some of the risks so that we can address them and prevent them in our workplaces. So the two main concerns I have that I see on a daily basis are human rights and privacy. So what we see is when personal information is revealed during a background check, it could end up that information that could lead to a protected ground under our human rights is shared. So that could be anything from gender to religion, even to substance use or dependence. So these are things that you might find out when you're doing your background checks. And if an employee is not hired, there are times when we see them bring these kinds of claims under human rights. In some cases, it's true. In most cases that I deal with, that wasn't the reason for not hiring, but that's what the employee or the candidate believes. So in order to reduce the potential for discrimination claims, I have the following suggestions. One is to limit the scope of the background check to include only information that is necessary to evaluate the candidate. Two, engage the services of a screening provider. So this is an agency like Sarah can tell you about even better than I can, but they can actually collect all the information, as you know, for the organization and give you do and don't hire type responses, so that you're shielded from some of the information that you wouldn't need to know or otherwise know. Extend a conditional offer of employment to the candidate before conducting the background check. This is very important. Our human rights in Alberta has come out to say, if you're going to start asking for a lot of personal information about somebody that can be sensitive, they want to know the employer is serious about potentially hiring that person prior to getting all that information. And so when you make a conditional offer, that shows, you know, we're pretty much going to hire you subject to the following. And we'll get into that in a little bit more detail, but conditional offers are pretty important when you're doing background checks. Finally, keep well-documented records. This is all about due diligence. And, you know, for example, in a discrimination complaint where the person says, oh, it's because you knew that I had this religion and that's why you didn't hire me, you can say, actually, no, here's the reasons why, and we actually have a file on this, so you're wrong.
Sarah, can you still hear me?
Yeah, I can still hear you.
Okay, sorry, my thing seems to be going in and out, but I think we're good now.
Yeah.
So privacy. The next, as I mentioned, there was discrimination and privacy are some major legal concerns when it comes to background checks. So I want to talk a bit about privacy. Alberta has privacy legislation that governs the collection, use, and disclosure of personal information by an organization in the private sector. So this includes the collection of job candidates' personal information. Violations for breaches of our Act can cost anywhere from $10,000 and $100,000 for breaches, and can also ground a cause of action in court if a breach is found. So to reduce liability of privacy violation claims, employers should consider extending a conditional offer of employment before collecting personal information. So just like I said with the human rights, it's the same from a privacy standpoint, is show that you're serious prior to getting the information that's going to reveal potentially sensitive information about a person by making a conditional offer of employment. So personal information is a broad definition. It means information about an identifiable individual. So that's the key there. It's about an identifiable person. So it's anything from race, national or ethnic origin, religion, age, marital status, gender, but then also educational, medical, criminal, employment history, as well as personal opinions or views of an individual. These are all things that are considered personal information about an identifiable person. So consent. Now, in Alberta, we have some provisions that deal with employee-specific information. So personal employee information is any personal information that's used to establish, manage, or terminate the employment relationship. For job candidates, employers are entitled to collect, use, and disclose job candidate information without necessarily having to provide notice or get consent. So an example specific to Alberta is job references. So job references can be sought and obtained without having to notify the individual candidate. Now, it is a best practice to collect references specifically from the individual and then inform the individual that you'll be contacting their references, but we actually do have provisions in our Act that give more freedom to employers to determine suitability. We've discussed some of the risks involved with conducting background checks. Now I want to talk about the checks themselves. Checks are really about due diligence. It's really about protecting your organization, but they must be reasonable. The nature of the job position will help dictate what is reasonable. So you see on this screen here, I've talked about some various checks, and now I'm going to go through them in a bit more detail. So employment history. Employment history is personal information, and it's relevant to the assessment of an individual, and I think in most cases employers will look for the employment history of their job candidates. However, there are some concerns that employers should be aware of. First, a false job reference can be defamatory, misleading, and second, all job references should be kept confidential. You want to make sure the information you're collecting is accurate. You want to make sure that when you are getting references, that they're only being provided on a need-to-know basis to people in the organization if they need to know, and that the information that you're collecting is verifiable, the information that you're going to be relying on. Employers are cautioned on searching a candidate's references through social media. We've got guidance in Alberta about social media and the dangers associated with doing background checks via social media. And the general theme is that social media might not be accurate because it could be old, false, or otherwise misleading information. So you want to make sure that you're being careful if you are seeing social media about a job candidate, because it might not be reliable. The other thing to consider is that because of access to information requests that are available under our privacy legislation, employers should treat all information that they collect as potentially scrutinized by either the courts or through a privacy request by the individual and potentially the privacy office. So another kind of check that we see quite frequently is fitness for work checks, and this is actually discussed by our Human Rights Commission as well. But fitness for work is really a determination of whether a candidate can safely perform the job requirements. The idea is to see if somebody's medically suitable and capable. Sometimes you see these fitness for work during employment as well when somebody's been off for illness or injury. Fitness for work assessments can include testing for drugs and alcohol. And if it's for a candidate and you're doing fitness for work exams, again, the law wants to see how serious you are about extending an offer of employment. So fitness for work exams should not occur until after a conditional offer has been made and accepted. It does vary province to province, though, and I want to make that clear. Drug and alcohol testing in particular is, besides being a hot topic across Canada, but it's one that varies in terms of the legal requirements. So where in some provinces like Alberta, you might see more pre-employment drug and alcohol screening, in other provinces it's going to be much harder to justify, such as Ontario. Criminal background checks, and Sarah touched on these, but from our point of view, we see criminal background checks all the time. Some of them are very slow and they can take a long time to come back. And I say this because when you think about certain kinds of checks, you have to decide, when do I want to put this person on the ground running? I'll actually go back for a second with the fitness for work tests. It's going to be hard for you as an employer to start somebody and then get a fitness for work exam back and find out that either they tested positive for drugs or they're otherwise medically unsuitable for the job you've already put them in. In Alberta, in our province here, we have guidance that says you're going to, basically have a duty to accommodate if you do that. And so, again, that's why you might want to use a screening agency, not start the person until they've passed all those conditions. The same as criminal background checks. Now, obviously, we don't have a duty to accommodate in Alberta. In some provinces, there might be, but the problem with criminal background checks, and Sarah touched on this too, is when you are bringing somebody in that you don't know the past background check for their criminal records, you don't know if they have fraud or other theft convictions. And I'm telling you, I've had a lot of clients where they've brought somebody in to a trusted position, even into a room with locked doors and all sorts of HR information, and only to find out later that they were a fraudster and there was tons of criminal records on them. So things to think about there are, one, do you start the person before you get the record check back? Two, if you do, what kind of position do you put them in? Do you put them in the high-risk position, because that's typically why you're doing the check? Or is there another sort of training or other position you can put them in until they start that position? And three, what do you do with the information once you get it back? So if it's a conditional offer and it's not satisfied, then the offer would be void. The other thing to consider, though, is if you have criminal record check practices in place, make sure you do them. Because as Sarah mentioned, if you don't, that can create a whole other host of liability, particularly if the person is a fraudster. So if you could have had that information and you didn't, but your practice was otherwise to do the checks, but you didn't, then you could have a hard time explaining why you didn't. The other thing to know about criminal background checks from a privacy standpoint and a human rights standpoint is that they vary in terms of the kinds of information they provide. Now, vulnerable sector checks are the ones that go directly to, a pattern of behavior that might affect vulnerable persons, and so you'll see those more in, say, school facilities. But other ones, like the police record check, information check, or the criminal record check, might have different types of information that could impact your organization's needs. For example, a criminal record check will generally only contain conviction information, whereas a police information check will provide additional information about conditional and absolute discharges, provincial statute convictions, including dangerous driving, and so forth. So there's more information that can come of it that might be pertinent to your organizational needs. So as I mentioned, in Alberta, criminal background and criminal records is not a protected ground under our human rights, but that doesn't go the same for every province or the federal jurisdictions. However, in Alberta, our Personal Information Protection Act still applies. And so employers have to be mindful that criminal background checks can still reveal sensitive personal information. From a human rights perspective, we can't be so lucky as to think human rights doesn't apply at all, because some of that personal information can include information about mental illnesses or substance dependence. So you can inadvertently get a whole bunch of information you didn't plan on otherwise having. In order to determine whether criminal background checks are needed for your organization, you should really be asking, is there a connection between the criminal background and the job requirements? And then if the starting place is yes, then you have to, as I mentioned before, decide what to do with the information once you have it. Once you have the information and you find out somebody had a conviction 20 years ago for shoplifting, is that relevant to the driving job that they're trying to get from you now? Quite frequently we see needs for driver's abstracts, and so either the standard driver's abstract, which is just the personal one, or the commercial drivers. Usually where driving is an essential duty of the job, from an occupational health and safety perspective, getting their driver's abstracts before employment and then during is a due diligence step. In the commercial driver's world, it's going to be a requirement. They don't have the same information. The standard driver's abstract actually has more about the personal characteristics of the individual. So you'll see there it's height, weight, sex, eye color. So it's got a lot of information there, again, that goes to human rights and privacy. The commercial driver's abstract doesn't contain all of that information, the height, weight, sex, but it does contain information really relevant to commercial vehicle safety alliance inspections and other commercial vehicle driving requirements. Again, some things to consider are to, one, if you have the programs in place to collect this type of information through driver's abstracts about driving records, make sure you continue to do it, because if you don't, you're going to have a hard time justifying why you didn't realize the person had suddenly, a really dangerous driving record when the driving is an essential duty of the job. So if you have a practice in place to collect the information every 3, 5, whatever it is years, make sure you do it. So this is just some information about how to obtain driver's abstracts. I also today wanted to talk to you about private investigators. It's a very interesting resource, because there are times when private investigators can be very useful to the business in order to collect background information. Typically, you'll see this when there's been a breach of an agreement or investigation of a policy breach, potential benefits frauds. That's where you'll see the role of private investigators coming in to collect private information. But you have to be very careful about determining whether there are any less intrusive means to collecting this information. You'll see there I've got the sort of 4 following requirements to consider when you're deciding whether to go with a private investigator. But I can give you an example. In the medical benefits fraud world, in one province you might find an employee committing potentially benefits fraud, the employer hiring a private investigator to follow the employee, catching the employee, and then being able to terminate on that basis. In another jurisdiction, you'll find the employee had driven to work that day. The employer said, wait a minute, they're not supposed to be able to drive. I'm going to hire a private investigator, follow him around. I caught him. And, the courts will say, why did you have to go through all that? You knew that from the fact that he drove. You didn't need to go and follow him and collect all that personal information, so we're not going to agree with you. So you have to be really careful when you're bringing in a private investigator to determine whether there really is a need and whether there's any less intrusive way to find out whether or not the policy is being breached or the agreement's being breached. So the law changes from province to province with the federal jurisdiction. In Alberta, we tend to see more leeway when it comes to pre-screening job candidates. From background checks to pre-employment testing, Alberta employers can employ a safety or risk-sensitive workforce with more comfort that they are placing a suitable candidate into the position. Background checks for these purposes are really important. Again, we have to remember to proceed with caution in order to avoid inadvertent claims of discrimination or invasion of privacy or other legal claims that can result. It is important to employ best practices, and I wanted to mention a few before I finish my side of the presentation today. It is important to employ these best practices to determine appropriate candidates for the job. Avoid doubling recruitment costs. Avoid having to terminate. It's important to limit the information that is collected, used, and disclosed, and ensure that safeguards are in place once you are collecting the information to protect it. Engage screening companies to assist with limiting the personal information that you are collecting. Make sure you're keeping everything well documented to protect yourself in the event of any sort of human rights or other legal claim. Make sure you are making conditional offers before you're collecting too much personal information. Consider internal documents, and email may be producible if you're being faced by a court or other tribunal down the road. And finally, and it wouldn't be a legal presentation if I didn't say this, engage law where appropriate to obtain legal advice and potentially the benefit of legal privilege. So those are the highlights of the legal risks that I wanted to talk about with background checks. And so thank you for your time, and I think now we'll turn it over to questions.
Thank you very much, Shana. We'll give it a couple minutes. I know that's a lot of information for everyone to digest, and hopefully we've kept you somewhat interested. Ultimately, at the end of the day, when it comes to screening, as Shana said, it's something that can help you far more than it can make your life harder. So we'll give you guys a couple of minutes. If do we have any questions in the audience? Shana and I are more than happy to answer. And also, if you're not comfortable communicating your questions via the webinar, Shana and my contact information is also available or should be available in the registration information. Okay, well, thank you everyone for giving us some of your time today. We look forward to hearing some questions via email, and thank you very much, Shana, for all your valuable expertise. Thank you guys for your time.
Thank you.